Welcome to this explainer. Today, we're mapping the exact legal machinery governing marine environmental jurisdiction to see how international treaties literally force nations to protect our oceans.
Here's our roadmap for today. First up, fundamental marine legal principles. Second, we'll look at the UNCLOS operative framework. Third, enforcement and marine jurisdiction. And finally, we'll wrap it all up with a complete legal framework recap.
All right, let's dive right into Section 1, Fundamental Marine Legal Principles.
Before we can really grasp the massive treaties that govern our oceans, we absolutely have to understand the bedrock principles of international environmental law. Let's start with a really simple everyday analogy. Imagine you own a house with a nice yard. You're perfectly free to enjoy that yard however you want, right? But what you absolutely cannot do is gather up a huge pile of toxic, poisonous leaves and just blow them over the fence into your neighbor's yard, ruining their property. It's a basic concept of neighborly boundaries. So, how does this translate into our first strict legal rule? Well, it's called the principle of sovereignty paired with the duty not to cause harm. In international law, nations, or states as we call them, have the sovereign right to exploit their own resources using their own environmental policies. But, just like that yard analogy, they have a corresponding responsibility to make sure that activities under their control don't damage the environment of other states or areas beyond their national jurisdiction. This exact rule is hardwired into Principle 21 of the Stockholm Declaration, Principle 2 of the Rio Declaration, and specifically for the marine environment, UN Clause Article 193. The key takeaway? Sovereignty is always paired with this strict environmental duty. And to see exactly where this concept comes from legally, we have to look at a classic case, the Trail Smelter Arbitration of 1941 between the US and Canada. Here's what happened. A smelter up in Canada was releasing sulfur dioxide that actually crossed the border and damaged crops in Washington state. The core legal issue was whether a sovereign nation could be held liable for pollution crossing its borders. The tribunal's holding was definitive. They ruled that no state has the right to use its territory in such a manner as to cause injury by fumes in or to the territory of another. Now, this isn't just some historical footnote. This is the foundational legal precedent, establishing that transboundary harm is a direct violation of international law. Okay, let's move on to our second principle with another quick analogy. If you're sitting in a crowded movie theater and you suddenly smell smoke, you don't just sit there waiting for a peer-reviewed scientific study to prove there's a fire before you pull the alarm, right? No way! You act immediately to prevent a catastrophe, even if you aren't 100% certain yet.
And this brings us to the precautionary principle, formalized in Rio Principle 15. It dictates that where serious or irreversible environmental damage is threatened, a lack of full scientific certainty is not a valid reason to postpone cost-effective preventive measures. This is absolutely crucial for marine ecosystems because, honestly, by the time we have perfect data on a collapsing fish stock, the damage is already done. This principle was famously cemented in the Velour Citizens Welfare Forum case, which legally established that scientific uncertainty simply cannot justify inaction when we're facing serious environmental threats.
Next up, think of an oil company being forced to fund the cleanup of their own spill rather than just passing the bill onto local taxpayers. This brings us to our third principle, the polluter pays principle, found in Rio Principle 16. It legally requires that the party causing the pollution must bear the cost of controlling and remediating it. The entire goal here is to force polluters to internalize the actual economic costs of their environmental damage, rather than externalizing those costs onto society or the marine ecosystem itself.
Fourth on our list is sustainable development. Basically, if you harvest timber, you must replant enough trees so the next generation also has a forest to log. As defined by the landmark 1977 Brundtland Report, this is development that meets the needs of the present without compromising the ability of future generations to meet their own needs. It's entirely about intergenerational justice. It's about ensuring we don't extract so much wealth from the oceans today that our grandchildren inherit a barren wasteland tomorrow.
Now, what's really interesting here is our fifth fundamental principle, which is actually a crucial legal distinction. It's incredibly common to confuse prevention and precaution, but they are entirely different legal triggers. Prevention deals with known, proven risks. You know the risk, so you take action before the harm occurs. Precaution, on the other hand, deals with uncertain, unproven risks. You take action despite the lack of scientific certainty. Remember this core distinction. Prevention presupposes you know the risk. Precaution operates precisely where you don't. Finally, if a toxic spill in your waters is drifting toward your neighbor, you don't just stay silent, you alert them immediately. This represents our sixth and final bedrock principle, the duty to cooperate. Now, this isn't just a polite suggestion. It's woven entirely throughout the international legal framework. States are required to cooperate in good faith on global marine environmental problems, and that includes notifying other states of imminent dangers and taking joint action. It's literally the connective tissue for all international marine law.
All right, moving right along to Section 2, the UN Close Operative Framework. Now that we've got a solid grip on those 6 fundamental principles, we need to see how they're actually weaponized in international law. This brings us to the United Nations Convention on the Law of the Sea, or UN Close for short, specifically Part 12, which translates these concepts into a binding operative framework. Notice how systematically it's structured. Article 192 is the big umbrella obligation stating nations simply must protect and preserve the marine environment. Article 193 directly codifies that very first principle we learned. Yes, you have sovereign resource rights, but they are strictly subject to that protective duty. Then, Articles 194 through 196 get incredibly specific, mandating states to prevent, reduce, and control pollution from all sorts of sources: land, seabed, vessels, dumping, you name it. Even the atmosphere. Finally, Articles 204 through 206 mandate strict monitoring and environmental impact assessments for activities posing substantial pollution risks. UN Close essentially takes the theory we just learned and turns it into a concrete, binding checklist of state obligations.
Let's jump into Section 3, Enforcement and Marine Jurisdiction. Here is the critical reality check, and really the climax of our legal lesson today. Principles and treaties? They are completely meaningless without jurisdiction. Jurisdiction simply means who actually gets to write the rules, and, more importantly, who has the power to enforce them. Think about it. If a ship dumps oil in the ocean, whose police force actually gets to arrest the captain? Historically, the primary enforcement mechanism has been flag state jurisdiction. This means a state is legally responsible for ensuring that vessels flying its flag comply with international standards, like the MARPOL Convention. But, well, there's a fatal flaw here, and it's called flags of convenience. Open registries in countries like Panama, Liberia, and the Marshall Islands compete for shipping business by offering low fees and pretty lax oversight. Because they want the business, they have very little incentive for strict environmental enforcement. So relying purely on the flag state often means relying on a state that's deliberately looking the other way. So, if flag states are weak, what about coastal state jurisdiction? Well, a coastal state's power drastically diminishes the further a vessel gets from its shores. Let's break this down. In internal waters in the territorial sea, the coastal state has full domestic regulatory authority, subject only to innocent passage. But once you move out to the exclusive economic zone, the EEZ, things change. UN Close Article 56 grants jurisdiction for marine protection, but Article 211.5 restricts this. A coastal state generally cannot unilaterally impose stricter than international standards on foreign vessels in the EEZ. This is a deliberate legal compromise to protect global navigational freedom. And out on the high seas? The coastal state has zero jurisdiction. It relies entirely on those often unreliable flag states. 200. That is a number you absolutely must remember. Coastal state jurisdiction is severely geographically constrained to a 200 nautical mile limit for their EEZ. Beyond 200 nautical miles, you are officially in the high seas, which leaves massive, vast stretches of our oceans completely unprotected by any coastal authority.
This obviously creates a massive legal loophole, right? Flag states won't enforce, and coastal states aren't allowed to. Enter the ultimate gap filler, port state jurisdiction, governed by UN Clause Article 2118. This is a total game changer. Under Article 218, if a foreign vessel voluntarily enters a state's port, that port state can actually investigate and prosecute a discharge violation that occurred entirely out on the high seas, even if the violation had absolutely no connection to that port state whatsoever. Regional frameworks like the Indian Ocean MOU on port state control operationalize this through routine, rigorous inspection regimes the very moment a ship docks.
Let's synthesize exactly why this matters. Flag states are too weak because of flags of convenience. Coastal states are too geographically limited by that 200 nautical mile rule in Article 211. Port state jurisdiction under Article 218 is the indispensable tool that actually makes international marine environmental law function in the real world. A foreign tanker illegally dumping oil in the middle of the ocean, completely ignored by its lax flag state, can still be arrested and prosecuted the very moment it pulls into port. It effectively closes the gap.
Finally, let's move to Section 4, Complete Legal Framework Recap.
Let's lock all of this in with a complete, structured recap. Check your notes against this review to make sure you have the exact terminology down. We started with the 6 fundamental principles. First, sovereignty, and the duty not to cause transboundary harm, cemented by the Trail Smelter Arbitration. Second, the precautionary principle, requiring action despite scientific uncertainty, validated by the Valor Citizens Welfare Forum case. Third, the polluter pays principle, forcing internalization of costs. Fourth, sustainable development for intergenerational equity, defined by the Brundtland Report. Fifth, that crucial distinction between the prevention of known risks and precaution against unknown risks. And sixth, the overarching duty to cooperate.
We then saw how UNCLOS Part 12, specifically Articles 192 through 206, turned those principles into a binding treaty framework. And finally, we analyzed the 3 enforcement mechanisms: the historically weak flag state jurisdiction plagued by flags of convenience, the geographically limited coastal state jurisdiction restricted in the EEZ by Article 211.5, and the ultimate modern gap filler port state jurisdiction under Article 218.
I want to leave you with one final thought to consider. We know Article 218 port state jurisdiction is the crucial gap filler holding this entire system together. But what happens to the global marine environment if polluting vessels calculate this risk and intentionally map their routes to only dock at ports known for having weak or corrupt inspection regimes? It really shows just how fragile our global ocean enforcement truly is, doesn't it? Thank you so much for joining me in this rigorous explainer. Keep up the great studying, and I'll see you next time.